everyone. The next topic of Law to 10 is about an offer. Who are the parties to contract that is involved with the contract? The first one is offeror. The offeror is the person who proposes the contract. The second party is offeree. The parties to whom the proposal is made is offeree. For example, if A makes an offer to sell car for 35,000 to B. What is an offer? According to Oxford Dictionary of Law, it defines an indication of willingness to do or refrain from doing something that is capable of being converted by acceptance into a legally binding contract. So offers, therefore, generally refers to a willingness to do or not to do something. Offers are usually made with respect to underlying terms or conditions of an agreement. For example, offer of a price. Offeror is the person who is making an offer. For example, Sue is offering to buy Jane's car for 5,000 pounds sterling. So the offeree is the person to whom the offer is made. In the example above, this will be Jane. An offer is an act or statement that proposes definite terms and permits the other parties to create a contract by accepting those terms. The problems with intents in this situation, first is going to be invitation to bargain is not an offer. Price quote is generally not also an offer. An advertisement is generally not an offer. Placing an item up for auction is not an offer. It is merely a request for an offer. Problems with definiteness is when you use the term of the offer, you must be definite. Invitation to treat, you can have the many examples in store. You can see on page 5 on your PPT, that is actually an example of invitation to treat. Offers distinguish from invitation to treat because an offer is not the same thing as an invitation to treat. Why? An invitation to treat is essentially an invitation to someone to make an offer. Therefore, it's not an offer. This invitation or offer can either be accepted or rejected by the offeree. In 1953, there's a case where Pharmaceutical Society of Great Britain versus Booth Chemists Corp. Limited. The items that were displayed for sales are invitation to treat. In the case of Fishers versus Bell in 1961, held that displaying a flick knife with a price tag in the shop window was an invitation to treat and not offer for sale. In the case of Harris and Nickerson back in 1873, it was held that an advertisement giving details of a forthcoming auction was not an offer, but an invitation to make an offer, upheld in Partridge versus Crittenden in 1968. Shop displays, catalogs, and advertisement Therefore, is actually an example where articles displayed for sale and advertisement, those are invitation to treats and not an offer, not offers. However, if you receive a reward or if you see reward posters, are considered to be offers, as outlined in Carlyle versus Carbolic Smoke Ball Corporation back in 1893. There are 5 key rules relating to offers, so you have to remember these 5 key rules quite because it's quite important. First one, an offer may be made to one or more parties. Offers need not to be made in writing, so they can be verbally said or informed. The offer must be communicated definitely so the other of the offeree will understand and the public will notice there's an offer. Revocation of an offer, otherwise of terminating an offer. An offer may be made to one or more person. In the case of Carlyle versus Carbolic Smoke Ball Corporation back in 1892, this is a case where a company advertised a flu cure. They said in the offer that if you use the remedy and then suffer from flu, they will give you 100 pounds sterling. They put 1,000 pounds sterling in the bank to show sincerity. A woman used it and caught flu. She argued that the company should give her 100 pounds sterling. So the court held that an offer can be made to many people. It need not simply be between two people. So the advertisements are not usually offers. However, the company intended it to be an offer because they deposited about 1,000 pounds sterling in the bank. In the case of offers, they might need not to be made in writing. Writing is a form of evidence that an offer has been made, but it is not a requirement. Therefore, oral offers and offers made by gestures, actions are recognized. So the offer also must be communicated. The offeree must be made aware of the offer by the announcer. So the offer must be effectively communicated so that a contract can be born. Revocation of an offer refers to its termination. However, an offer can only be revoked if the offer has not yet been accepted. The offerer must communicate the revocation to the offeree. For instance, in the case of Briney versus Van Tienhoven in 1880, when someone pays to make an offer for a certain amount of time, example an advertisement in a newspaper, then the offer cannot be revoked until that amount of time has elapsed. Otherwise of ending an offer. This is very interesting. Offer might also be terminated by one of the following ways. First is refusal. In this situation, the offeree refused to accept the offer. The second way is to counter-offer. When the offeree rejects the offerer's original offer, then makes an alternative or counter-offer for the offerer to consider. The original offer can also be varied, in which case the new offer will also be considered as a counter-offer. The third way is that lapse of time. The offerer in this case can state that his offer will only exist for a certain amount of time. But if he does not state a time period, then the offer will last for a reasonable period of time. This will vary according to the fact. And the last one is death or either party. However, if the person accepting the offer does not know of the offerer's death and the deceased offerer's representatives are able to carry out the contract, then the offerer will not end. What is actually the element of contract in regards to the offer? First is definitely an offer. Then there's acceptance, followed by consideration and the intention to create legal relations and the capacity of the parties who are involved with the contract. Next, we are going to discuss the essentials of offer. It must be an expression of the willingness to do or to abstain from doing something. It must be made to another person, yeah? It should be done with an objective to obtain the assent of the other person. Therefore, the objective of offer should be legal one. On page 16, you will see the chart of offer that cover its definition. Offer must be certain and numerous of types of offer. Revocation of an offer and communication of revocation, you can coming from communication of an offer, then it was coming from to whom offer can be made. Offers distinguish from invitation to treat. This is actually can be explained like this. When the tender notice is not an offer, calling for tenders to sell a product or buy a product or service will not amount to an offer. All the prices quoted by others to the tender notice are offers. He can either accept or reject the offer. Tenderer is not bound to accept the lowest price or highest bid. In the case of auctions, auction are requests for bids. Bids are the offers. Auctioneer might accept or reject the offer. Therefore, unless there is a condition that the highest bid will be accepted. Is that an offer? No, it is an invitation to trade. Give an example that you thought this product was previously is an offer. You can see also check if which one is an invitation to trade. Invitation to offers displays a display of goods by a shopkeeper in his window with prices marked on them is not an offer but merely an invitation to the public to make an offer to buy the goods at the market the marked price, and you can have some of name tag with a different price code. A person to whom an offer might be made. A person is said to have made a proposal, for example, when he signifies to another his willingness to do or not, or to abstain from doing anything, with a view to abstaining the assent of that other such act or abstinence. So, offerer or proposer or promiser is the person making offer, while offeree or proposee, those are person or people to whom offer is made, and offerer accepting the offer is acceptor or promises or promise. To whom an offer can be made. It can be for one person, it can be a group, or the whole world. All offer must be communicated to the offeree. So a person can not accept an offer without having knowledge of the offer. Example, Mr. A loses his dog and he put up an advertisement in the papers that anybody bring his lost dog will be given a reward of Australian dollar 10,000. Mr. B finds a dog on the road and he identifies that the dog is Mr. A's or the owner of the dog is Mr. A. He catches the dog and hand over it to Mr. A and go home. On his way back, he meets Mr. C, a good friend of Mr. A, and he tells him about the loss of Mr. A's dog and reward available for the finder of the dog. Mr. C will not be able to claim the reward now as he did not act upon the advertisement. He did not know that there was a reward before he finds and handed over the dogs to Mr. A. When does an offer come to an end? If it's, for example, revocation, there's a lapse of time, there's non-fulfillment of a condition by death or insanity, if counteroffer is made or not accepted according to prescribed mode, if the law is changed. Next, we are going to discuss about termination of an offer. Termination by you can do termination by revocation, which is actually effective when the offeree receives it. Firm offers and revocability. How does it sound? Yes, it's work. For example, common law rule. Revocation of a firm offer is effective if the offeree receives it before he accepts. What about option contract? The offeree might not revoke an offer during the option period. Last one is sales of goods. A writing signed by a merchant offering to hold an offer open might not be revoked. The other one is termination by rejection. If an offeree rejects an offer that you have created, this rejection immediately terminates the offer. A counteroffer, meanwhile, can operate as a rejection. What about termination by expiration? When an offer specifies a time limit for acceptance, that period is binding. If the offer specified no time limit, the offeree has a reasonable period in which to accept. Next, we are going to discuss the topic on lapse and revocation. All this actually has already available as part of an offer. An offer lapses after stipulated or reasonable time. An offer lapses by not being accepted in the mode prescribed. An offer lapses can be by rejection. When an offer lapses by the death or the insanity of the offerer or the offeree before acceptance. An offer lapses by revocation before you can accept it. An offer lapses by subsequent illegality or destruction of subject matter. You can see the example on the previous statement on page 28. So I'm give you an example. We are going to learn step by step on this example. For instance, a proposal by a letter sent by post to sell his laptop to B. Then the letter is posted on the 1st of March. B accept the proposal by a letter sent by post on the 4th of March. So then the letter reaches A on 6th of March. A might revoke his offer at any time before B posts his letter of acceptance, example on 4th of March, but not afterwards. B might revoke his acceptance at any time before the letter of acceptance reach A, for instance on 6th of March, but not afterwards. You will see the case on page 29. A and B were talking one day after college. A would turn 16 on the upcoming June and wanted to buy B's car. B, 21, had been working and saving his money to buy a new car. Selling